I was just I'd just finished dealing with Miss Shaw's statement. We saw that Miss Shaw was really not able to do much more than provide be a vehicle for, if you'll forgive the pun, the exhibiting of documents. In terms of those documents, even there were considerable limitations. Most of the original transaction documents were not available, and Miss Shaw provided templates or equivalents from other transactions. Now, I'm not going to go through those because no particular reliance is placed on them by any party. One document that was exhibited and is relied upon in my learned friend skeleton is the so-called broker guide, which is in the Hopcraft supplemental bundle at tab 10. But as soon as we turn to this, we can see that it's irrelevant, and it must substantially postdate the transaction. It refers to the Financial Conduct Authority regulation at the bottom. And not only that, I've tried to date this document, and I can do so because if one goes over the page, you obviously see reference to the FCA rules and the Financial Conduct Authority handbook, none of which was in place. And on page 58, there's even a reference to the consumer duty. Now, the consumer duty was a new standard introduced by the FCA in 2021. It came into effect in 2023. So although my learned friends make some points about the broker guide, and that's a reference, paragraph 134 of his skeleton, there's a very short answer to that. Totally irrelevant to this transaction.
Right, but it's you that's produced it.
But it's entirely our fault. But that's where we are. Yes.
I just wonder what the court's supposed to do when it's supposed to be trying to work out what a bank and a dealer did 10 years ago, and the bank produces either nothing or nothing of any value.
Well, I think to be fair, below it no party paid any attention to it. No, as far as I can see.
No. Just while I'm on that,
yes,
very briefly. I don't want a long answer to this, Mr. Wilson, but just in a sentence, what is the position in relation to limitation in this claim?
Yes, if I was starting this case fresh, I would say it's time barred, and that was pleaded in the defence.
Yes, I saw.
But it doesn't seem to have ever been taken as a point, and I've been speculating as to why that might have been. It might have been because below Section 140A claim was included as well. It might have been thought, and I make no comment as to why that's right or wrong, but that caused difficulties as far as the limitation defence was concerned. I think then what happened is, on appeal, that point was dropped, but it was too late to raise a limitation point.
Thank you.
The other thing I just wanted to mention briefly before we go on is the regulatory context, or rather the lack of regulatory context in my case. This is tangential because, as what I say in paragraphs 69 to 72 of our skeleton argument, our position is that regulation and private law are two distinct things, and one can't really read across one from the other. But the point, factually, I need to emphasise is simply that this is a pre-regulation case. It wasn't until the 1st of April 2014 that consumer credit in this sort of area became regulated by the Financial Conduct Authority. That's common ground. Conc rules didn't exist and didn't apply. And before then, and at the time of the transaction with which we are concerned, persons involved in the provision of credit to consumers had to be licensed by the Office of Fair Trading. The OFT did not promulgate rules in the same way that the FCA later did, but it simply published guidance, and that guidance was there to inform its decision as to whether to grant and or revoke licenses under the Consumer Credit Act. And again, I'm not going to go into any detail of that because I think my learned friend, Mr. Weir, accepts that that was position. He accepts that the guidance was just that. He says that in terms, I think, in his skeleton argument. It didn't have legal effect. It wasn't dealing with private law rights and obligations. I should also show you that there's a distinction in our case from the other cases about the underlying definition of a credit broker. That was at the time defined by section 145 of the Consumer Credit Act, and that's in the additional authorities. In my bundle, it's the third bundle. I'm not sure if that will be. I'm looking for tab 50. Tab 50, yes.
Bundle 3.
Bundle 3. Thank you. I'm very much obliged. In fact, it's tab 51 at page 1501. And we can see at the top of that page, this is the version of the Consumer Credit Act that was in place between the 26th of July 2013 and the 31st of March 2014. And a lot of this was amended once the regulation came into effect on the 1st of April 2014. But at this time, as we see from section 145, subsection 2, credit brokerage was defined as the effecting of introductions between A, and I'm going to summarise this, the person seeking to obtain credit, and B, the person, effectively the lender or hirer, and B is a situation where dealers are put in touch with individuals desiring to obtain goods on hire. But the simple point is it was defined as no more than the effecting of introductions. And so one can't read anything into the label, certainly in my case, credit brokerage of itself. Article 36A of the Regulated Activities Order, which Mr. Hardwick took you to, does not apply in my case. Now, I just want to spend a moment drawing some of that together, having now seen the factual findings and the evidence and understanding the regulatory context, and what that means in terms of the respective roles being undertaken here. And Mr. Weir understandably takes a consumer-centric view of the dealer's role, but in my submission, the dealer's function needs to be looked at in the round, and as I think there's been previous discussions at this point, the reality is they are, of course, doing things on both sides of the transaction and in their own right. And you can, if you really look for them, find limited ad hoc agencies or not. In my submission, that's not even a particularly helpful exercise because it doesn't answer the question of whether those functions, ad hoc agencies, if you want to call them that, give rise to fiduciary duties or anything like fiduciary duties. Now, in terms of analysing what's actually going on in one of these transactions, I'm grateful to my learned junior, Mr. Day, for the analysis I'm about to set out. That's not to say I blame him if it's wrong. I take entire responsibility if it's wrong, but if it's right, he should take all the credit. It goes like this. It's simply in classical offer and acceptance language. You can think of the car in the showroom as an invitation to treat, as one could with any goods in a shop window. If the customer is able to pay cash and makes an offer to buy, that's accepted by the motor dealer, that's that, the contract is formed. If the customer comes and says, well, I want to obtain finance, as in our case, that involves the use of third-party finance, one could analyse that as the customer making its own invitation to treat. I, as a customer, invite you, the car dealer, to make an offer to me to enter into a finance agreement in respect of the car on terms that I can afford. And to enable you to make that offer, I, the customer, provide certain limited financial information. And then the next stage is that the motor dealer uses the financial information to obtain an offer from a third party, here, Close Brothers. So in obtaining and communicating back to the customer the terms of that offer, the motor dealer is acting, if anyone, is acting as agent for the third-party lender. It's the third-party lender's offer. Now, that offer can be accepted by the customer or not. And in our case, it's on a take it or leave it basis. And then what we're describing is the commission paid, and it's only paid on one side of the transaction. The customer isn't paying a fee. Therefore, reflects, one can think of it in these terms, as reflecting who is in fact authorising the motor dealer. It's paid by the financier who's authorised the offer to be made on its behalf. And then once we get into a different analysis, once the transaction has been agreed, once things have gone through, title in the car passes to Close Brothers, and the car dealer retains possession of the car merely as bailee, to address a point that I think was raised previously in this hearing. And in that sense, they are holding possession as agent of Close Brothers, and when they come to deliver the car, they must be agents of Close Brothers at that stage as well. The alternative way of looking at it, the way that is my slightly more simple, perhaps naive way of looking at it, is to say, well, it doesn't necessarily need to introduce agency concepts into this. Jordans were an introducer, as per the definition of credit broker at the time. And this is going to be quite close to the outlined analysis of Mr. Hardwick at the end of his session yesterday. What Jordans are really doing here is introducing two parties, two principals together, each of whom will be involved in the finance agreement. The dealer has authority from each principal to do that. It has limited authority from Miss Hopcraft to approach a finance provider and to communicate certain, albeit very limited in our case, information about the financial circumstances. But Jordans must equally have authority from Close Brothers to obtain the information that they want and they need to make their own credit assessment and to decide whether to put forward an offer of finance. And so that doesn't mean that Jordans is acting on behalf of any one party over another. And most importantly, and this is really the point, it doesn't give Jordans anything approaching a power or discretion over the customer's affairs. And that's why I said earlier that it's not enough to simply try to identify within this chain of arrangements ad hoc agencies. The question is whether they give rise to fiduciary duties or the disinterested duty. I'm going to speak about the connection between those two in a moment. But my point is really this. These acts of communication and passing on information and the like of it do not engender wider expectations, I'm looking at this objectively, on either side of loyalty, trust, confidence, impartiality, or anything of that nature. And often, when we're talking about an introduction or an introductory role in a commercial context, that introduction is typically made for self-interested reasons. In the commercial world, it can be expected that the intermediary would expect to benefit personally from the introduction, certainly if it leads to contract coming into place. And that, in a nutshell, is what I say the factual position here is. Jordan's function can be described as essentially introductory and administrative, and they're making that introduction directly and specifically in their own interests, and in the interests of the customer as well. And I agree with the point that was being made by the bench earlier, which is, in a sense, that one could describe this as an affinity of interest, a mutual interest. To which my answer is, well, that's not the same as a position of selfless disinterest. Those are two different concepts. Now, I then turn to the appellant's challenge in Hopcraft. What exactly is the challenge? What exactly do they say went wrong, as it were, below, that justifies this court overturning the decision? As I said earlier, and I do emphasise this, they are not challenging any of the findings of fact made by the judge. So on precisely what basis is my learned friend saying that this court should now make a finding of liability? Now, summarising this as best I can, and I apologise if I get this wrong in any way, but what I took from my learned friend Mr. Weir's submissions, particularly on Tuesday, was that effectively it's inherent in the function of a credit broker, of virtually any kind, that they must owe the Wood duty of impartiality. And that seemed to be based factually on 3 points as to what a credit broker actually does. And the points I got out of it were: 1, it takes information from the customer about his or her financial circumstances and what it is the customer wants. 2, the broker puts that information either to the market or a subset of the market, which we're describing as a panel of lenders. And 3, it presents a proposal to its customer having made a selection. And it seems to be that last point, having made a selection, which seems to be absolutely critical to my learned friend's case. And he says on that basis, the disinterested duty arises. And really the ambition of my learned friend's case is to say it arises in all of these cases. Absolutely as a matter of course. The logical extent of his submissions is that credit brokers are just always going to owe these duties. I suppose he would say unless there are exceptional circumstances. What I wrote down from Tuesday on that point of how wide the submission was is if you, meaning the broker, make a selection, you will be under a disinterested duty. And again, as I say, it's because it seems on his case it's inherent or implicit that in making a selection, the broker will be making the selection that is most suitable or the best deal for the customer. Now, there are at least 3 problems with that in my submission and in our appeal, which I'm only dealing with our appeal. The first problem, and I'll develop each of these, is that it misunderstands and misapplies Wood and indeed the preceding cases. The case law to date does not say that every credit broker, or even every credit broker making a selection, is bound to owe the duty of impartiality. They do not say that you can ignore issues such as whether a fee is being paid, whether or not there are express terms of business imposing particular duties or responsibilities, and so on. And I'll need to look at those cases. The second problem is his approach cherry-picks the facts, ignores other facts, and indeed in our case introduces factual elements which simply weren't there in terms of the primary factual findings below, and they don't follow from those findings. And I've already dealt with the evidence, so I'm not going to go back over that. And the third problem is it tries to, and has to, ignore the overall factual context of this case, which is the point, which I'm not going to labour because you already heard submissions about it, but it's the point about the dealer's inherent and manifest interest in the finance transaction itself. I may need to come back to that, but only briefly at the end. So I want to start with the authorities and to what extent they support what my learned friend is saying. And I'll start with Wood itself. Before we turn it up, I'll just make this proposition. Wood is not authority for the proposition that every intermediary carrying out the function of introducing a lender to a customer, even if it is carrying out a selection, must by definition owe the duty of impartiality and hence cannot take a commission without disclosure. There is no point at which Lord Justice David Richards says that, and it does not follow from his reasoning. On the contrary, he is saying that it is fact dependent, and we see this from various passages. Now I do need to turn upward. We've seen that it's the core bundle of authorities, tab 11. And starting please at page 260. You will see at paragraph 47, the last sentence there is that the precise scope of the duties of the brokers in the present cases, as in all cases, will require examination by reference to their terms of engagement. And then he applies that, or rather supports the conclusions reached in the lower courts. If we go over to page 271, at paragraph 103, he is talking about the Pengley case here. He says Mr. Justice Marcus Smith held that by virtue of its terms of engagement, the broker owed a fiduciary duty to Mr. Pengley. And then if we go back, we could see what the terms of business were. And I think you've been showing this, but it's worth just going back to see what he's referring to. That's back on page 252. At paragraph 16. And we saw that those particular terms of business included under A, B, and C, we work from a panel of lenders to enable you to select the appropriate lender and mortgage product to meet your individual circumstances and need, and we will therefore be acting on your behalf. Expressly set out. We will confirm our advice in writing. And then paragraph 17, printed on the reverse side of the terms of business with standard acceptance. We instruct you, and so this is the customer instructing the broker to endeavour to restructure, renegotiate in our existing finance agreements, arrangements, and provide ongoing advice. We undertake to be bound by the terms and conditions. 3, we confirm that the information is given and complete, and it gives then full authority to negotiate on our behalf from the date of signing this acceptance until such time as alternative instructions are given. And then we get, we go back to the commentary, as it were, on the lower court decisions. We looked at page 271 at paragraph 103. We then look at paragraph 105, dealing with the findings of Mr. Pickering at first instance in the Wood case. Over the page, 2-3 lines down, Lord Justice David Richards says the broker did not just randomly source lenders, but selected lenders based on what Mrs. Wood said she was looking for. And that resonates with the point I was making earlier on. We've got to know what the customer is actually looking for in order to select the best deal. And in doing so, acted on her behalf, which is not surprising given the terms and conditions we've just seen. The broker charged her substantial fees in respect of 2 of the 3 loans. The terms and conditions stated that the broker was acting on her behalf and would complete a detailed questionnaire to enable appropriate advice to be given to you on your mortgage requirements. And then the key paragraph in this judgment is then 110, where Lord Justice David Richards says, in my judgment, both Mr. Justice Marcus Smith and Mr. Pickering were unquestionably correct to hold that on the basis of the broker's terms and on the basis of the findings of fact at first instance, which I emphasise, the broker owed duties which engaged the law applicable to bribes and secret commissions. It was under a duty to make a disinterested selection of mortgage products to put to its client in each case. To the extent that is necessary, they are also correct to hold that the broker owed a fiduciary duty of loyalty to Mrs. Wood and Mr. Pengley in the performance of its duties. Now, I appreciate that Mr. Weir says that and he's effectively seeking to apply certainly that duty to the Hopcraft case. He says, well, although those factors have been mentioned, you don't necessarily need them. You don't necessarily need, he says, a fee to be paid. You don't necessarily need advice to be offered. You don't necessarily need written terms of business. And he relies, we've seen on the other cases, Firstrand and McWilliam. Now, my position is, to be clear, I totally accept that none of those are necessary preconditions of liability in every case. But they are clearly relevant factors that a first instance judge can and properly should take into account in making an overall assessment. And that's what happened in our case. in our case, it was thought relevant by the district judge that there was an absence of a fee, for example. He did think it relevant. There was an absence of a contract between the customer, by which I mean terms of business for the purposes of credit broking, between the customer and the dealer. But in the absence of a fee being paid, in the absence of any actual advice being offered, one would normally expect that to be a strong indication that the broker is, as I suggest, simply acting as introducer and has no greater role and hence no greater duty. And the relevance of the absence of written terms goes a bit further. The importance of the written terms in Wood and other cases is it gives something for the court to look at, to determine the nature and the relationship, the extent of the powers, if any, which the dealer has over the customer's autonomy in affairs. And then, having looked at that, the court can decide whether those powers should be subject to, in orthodox terms, fiduciary constraints, or in these terms, well, I think they still are, and I'll come on to make submissions. They still are fiduciary constraints. Constraints about not making a profit, constraints about not being allowed to get into a conflict of interest. But what does the court do in the absence of any terms and conditions which specify, as they did in Wood, what the relationship between those parties is? All it can do is look at what actually happened, what the customer and the dealer actually said and did in their interactions. And that, in my submission, is effectively what the district judge was doing below. He saw from the evidence that was available to him what those interactions were, and in effect, he concluded that there was nothing in those interactions from which one could discern that the dealer would have been understood objectively to have assumed responsibility for the appropriateness or suitability of the finance which it was offering. And that's largely because of the facts we've seen. And I was going to go back over some of that, but I'm not going to. In terms of the other cases, Hirstanger, McWilliam, and so on, equally, none of those support the proposition that merely because the broker is making a selection, he must, as a matter of course, be under the disinterested duty. I'm going to try and cut this bit short, as I am with certain other aspects of my submissions, by reference to my skeleton argument. And I deal with this, our skeleton argument is in the core bundle at tab 3. At paragraph 61, which is on page 113. And really the purpose of paragraph 61 in our argument is to explain why the Hopcraft case is different from the cases that we refer to here, Hirstanger, William Nelms. We also refer to Medstead in the footnotes. In Hirstanger, there was no issue about, there was no real issue about the credit broker being a fiduciary. That was, as I understand it, conceded at the county court level, and that's why we see very little discussion of that point in the Court of Appeal judgment. I'm not going to go back over that. In terms of McWilliam, I do want to just look at a couple of aspects of this, because there was one point that my learned friend skipped over, my learned friend Mr. Weir skipped over when he was looking at this case. So McWilliam was in the core authorities bundle at tab 6. Sorry, at page 86 of tab 6. I just wanted to draw this to your attention first. It was a case where only one side was represented, and Lord Justice Tomlinson's own warning at the end of paragraph 9 was about not this being an unsuitable case to raise issues of principle applicable to any other cases. And the court has had to resolve difficult and contentious issues without the assistance of adversarial argument. So on the court's own, we should just take heed to the court's own warning, as it were, when looking at the rest of this case. But what I wanted to look at was page 96. Because this is the bit that my learned friend relied upon. He took you to paragraph 38, and he read out the first sentence. I think he may, to be fair to him, I think he may have read the whole of paragraph 38. But the first sentence says, on the basis of those facts, it is apparent that the task of the broker was to identify that lender willing to lend to these borrowers which offered the terms most advantageous to the borrowers. Now, again, he is not saying, the court is not saying here that this task of finding the most advantageous terms is inherent to all credit brokers. He is finding that, he is saying that is based on the facts. And the facts are those set out in the earlier parts of the judgment, and in particular paragraph 37, where there was a finding at first instance that what the broker was doing in that case was finding the most competitive rate that matched the borrower's criteria, indicating they had obviously set out their criteria to the broker. And we know as well in this case the borrowers were paying fees, the total fees, if we look at paragraph 2, in combination there was a £750 broker fee and a completion fee of £500, so £1,250 in total. And this bit's slightly more difficult, but as we read this case, the borrowers were looking for advice in that case. My learned friend took you to paragraph 46 in suggesting otherwise, and he read these words. More generally, as it seems to me, the circumstance that the claimants were not looking to Norton for any advice or recommendation. Then he rather skipped over that other than that to which I have referred. And he says it's not relevant to the question of whether a fiduciary duty was assumed, but just to understand the facts, that seems to be not entirely clear what he then means by I have referred, but it seems to be a reference back to paragraphs 37 and 38, where it looks as though the customers were looking, in effect, for advice as to the most competitive interest rate. In any event, he concluded that that was the task of the borrower on the facts of that particular case. I won't dwell on that because we've made that point in our skeleton argument. At paragraph 61.2, sorry, I'm being asked to also show you paragraph 44.
Not surprised because I've highlighted it.
There we are. There were two people in this room who were ahead of me, as always.
I think I highlighted it when Mr. Will went through it. Actually.
Thank you very much. Well, I won't dwell on that.
But yes, I mean it's a perfectly fair point. There's a finding in paragraph 44 that the advice and recommendation, there's no indication that whatever was said in Firstrand went beyond what was said in McWilliam, and it was drawing an equation between the two.
Indeed, exactly. I'm grateful, lady. The short point. I won't go over all of the cases. In all of the cases, there was some proper factual basis on which to conclude that whether it's obvious or whether it's expressed or implied, but the role actually being undertaken by the broker is to do something very specific for the customer, to find the most advantageous, the most competitive lending terms, the lowest interest rate, whatever they specifically wanted on those facts. And that takes us back to the distinction factually between that and this case, and also we have the other, an important distinction with this being a situation unlike the other cases where Jordans themselves have not only a role to play but an interest in the resulting transaction, because in very simple terms they get the money. And I should just go back just to finish this off, because I realised I didn't show the court the last part of the decision of the district judge below, which is in the core bundle at tab 36.
This is the bit that deals with the absence of the finding that they were effectively acting as a conduit and not as advisors.
I was thinking of, that may also be here. I was going to take you to page 405.
Yeah.
I think you'll have seen. Paragraphs 40, 41 and 42,
Yeah.
just to make sure I've addressed those points, which are important to us.
Yes.
Where he says, I have to judge this matter on the circumstances of 2014, although the responsibilities of brokers, not necessarily motor dealers, have now changed. The question is asked, and I ask it, at what point in the dealings between the claimant and Jordans do they, Jordans, turn from a company contracting to profit from the sale of a car to a credit broker required to give information, advice, and recommendations on an impartial or disinterested basis? And I would add they'd do that for no additional fee, which comes round to the implicit. He doesn't quite answer his own question, but it's obviously rhetorical and implicit. He's saying that he can't identify any such point. Then he makes the point again that there was only the only evidence is that they had one deal that was offered, and that was that. And then 42, Jordans were not impartial and not disinterested. In my view, they had no duty of responsibility to be so to the claimant. They were not the agent of the claimant in any form. And in my view, the defendant did not expect them to be the agent and did not pay commission to them, knowing or believing them to be the agent of the claimant. The claimant was not seeking anything other than a deal within her budget. That's very important. And as I've said, even then she went beyond her budget, paying £20 or £24 a month more than what she said her budget was. And then he dismissed the appeal on that basis. And I've tried to deal with it as quickly as I possibly can. The short factual answer to this appeal is the judge was entitled to reach that conclusion on the basis of the primary facts, and that was within reasonable bounds, and there's no basis to interfere with that. And that is the less punchy point concluded. Now, I am not, and I've thought about how to deal with this, I am not going to be able this afternoon to give this court a full treatise on would disinterested duty, how it ties in with orthodox, or doesn't tie in with orthodox fiduciary law, and make all the submissions I'd necessarily want to make about that. I think what I'm going to do, if I may, is deal with following points and make a suggestion as to how to deal with the remainder. I can explain why we're making this challenge, and it's part and parcel of explaining why there is some confusion in county court level at the moment. I can try to make some points about why it's permissible to question Wood and potentially depart from its reasoning, or at least reinterpret it. The stages that are then more difficult for me to go through in the time available are these. They reflect the aspects of Lord Justice David Richard's own analysis in Wood. I mean, essentially, I've narrowed it down to three. What he does first is take 12 or 13 cases, which he says or justify his departure from an orthodox fiduciary requirement, because you can read them as not necessarily being fiduciary situations. And my learned friend says, well, you could equally read those as an ad hoc fiduciary. So there's not much between us. That doesn't mean that's how that Wood is always being interpreted in that way by others. And then secondly, and this is really the most important point, insofar as Wood is articulating a separate disinterested duty, there are questions about what that duty is and what you need to do to meet that threshold, as it were. And I think that's the point I must address orally today. And then lastly, there are points about his reasoning in terms of the common law of bribery and the available remedies. What I propose to do is deal with those threshold points, explanation of why we're doing this. Deal only very much in outline with and in categorisations with the cases that Lord Justice David Richards dealt with. But deal with the meaning and interpretation of the disinterested duty. And then insofar as the remaining questions of common law remedies, there are points that I think I would otherwise leave unanswered unless I answer them in some way. But I'm going to suggest I deal with that in a note that is confined only to those issues. And so what I'll try to do is finish by...
Well, I must say, I haven't asked the rest of the bench about this, but we have been deluged with documents in this case. And that's not a complaint. It means that everybody has been exceptionally thorough.
Yes.
And of course we have sympathy, Mr. Wilson, with the fact that you're third on your feet, well, fourth on your feet after Mr. Popwell, but third party, and obviously this is a case that's important to your clients, and
yes,
you should have a fair crack of the whip. Whether having a fair crack of the whip means having a full chance to argue all the points you want to on why we should depart from another decision of this court, which is binding on us, and whether you should do that in writing following a very full and lengthy hearing, I have some doubts.
Okay, all right. Well,
As I said, if either of my colleagues think differently, then of course I'm in their hands. But speaking for myself, I don't think it would be terribly useful.
Speaking for myself, Mr. Wilson, listening to what you said, I would value hearing the bits that you said you were going to hear orally. All three of those do sound to me as though they're things which would be very useful.
Yes.
let me do
If I may pay tribute to your skeleton, I think your skeleton actually deals with those other two things pretty well.
Yeah.
very well. I'm very content with that. Whatever's most helpful for the court. All right. First, why it's appropriate to, and why we are wanting to look at Wood more widely. There are three reasons for this. First, whether or not it was the intention, Wood has been perceived as affecting a significant change in the law. It has been seen as removing the requirement for establishing a fiduciary relationship or fiduciary duties which had previously been understood, as we've seen from the previous case law, as a precondition of the engagement of the law on bribery and secret commissions. And now the test, as it's summarised, the classic summary of Wood is you, the county court judge, need to just find two things. Did the dealer have a role in the decision-making process? And one of the problems is there's a lack of clarity over what a role means, and that can potentially be interpreted in a very wide way. Secondly, did the dealer owe a duty to be disinterested? And the problem with that is without more guidance, there's a problem of potential circularity. And that arises not least, and always exemplified, not least by one of the things my old friend Mr. Weir said on Tuesday, and he said, this is from my junior's notes, the disinterested duty springs from the duty not to profit and not to have a conflict of interest. Well, that doesn't help in my respectful submission. The no profit and no conflict rules are a consequence, classically, of being in a fiduciary position. And most importantly, how do you know whether a dealer is under a duty to be disinterested? That's not being answered in a consistent way, and one needs to consider what the factual circumstances actually giving rise to that duty are. And then I'm in danger of trespassing on grounds that don't really affect me in my appeal. But I'll just say this, that the Wood decision has, and this is a common perception, it has left this odd distinction between the so-called half-secret and fully secret cases. I don't particularly like or adopt that terminology, but that's the terminology that's being used, I don't wish to cut across the submissions of either of my learned friends on this. I'm simply saying that before Wood, there was no such distinction between those two situations. They were both understood to require fiduciary duties as a starting point. It's only after Wood that that distinction has arisen. And
Mr. Weir would say that Wood has changed the landscape completely and there's no distinction, but it goes the other way.
yes, he would, and others, and I would be one if this were my case, I would say you simply need a fiduciary duty in all cases. And my learned friend Mr. Hardwick says there has to be a different approach depending on whether you consider it to be half secret. So there's three possible solutions to that. And then the final sort of question in my list of questions is what is the difference between the fiduciary duty or disinterested duty? By which I mean, what is the practical difference in terms of the evidence that needs to be put forward, the underlying criteria for establishing such a duty? Is a disinterested duty a lower test than a fiduciary duty, or does it really require come down to the same sorts of concepts as fiduciary duty concepts and require the establishment of the same facts? And the linked reason to all of that is there are seen to be inconsistencies between the Wood decision and other decisions, including this court, and I'm going to touch upon that. And you'll have seen from our skeleton argument, there are, certainly in the academic world, a number of people who think the decision in Wood was not correct in its reasoning, that there shouldn't be a disinterested duty which is distinct from orthodox fiduciary principles, and in a sense I'm merely representing that and putting that forward to the court as those views. Now, in terms of the threshold point, if this court were to reconsider Wood, I've made the point. I'm not saying the relevant reasoning in Wood is obiter dicta. Really, it comes down to this. We have difficulty in reconciling Wood with two other lines of authority. The first is that there is an authority in terms which says, and it was decided not so long ago, that a fiduciary duty is a precondition to the engagement on the rules on bribery. And that, when you really look at it, is Ease and Conway. And that's a recent Court of Appeal decision, which considers many of the same cases that were considered in Wood, and considers the same issue and comes up with a different answer. The second, and this is a somewhat broader but related point, is that if Wood is espousing a no-profit rule outside of the law of fiduciary obligations, that seems to us to be contrary to those authorities that say the no-profit rule is an equitable rule that is unique to fiduciaries. And the key authority there is Mothew and Bristol and West. There's a short point, just a preliminary point, as a matter of precedent. And this is set out in my learned friend's skeleton argument. Actually, it's a supplemental skeleton argument in the core bundle at tab 39, page 448. Where we don't take issue with much of what he says about ratio decidendi and so on, but at paragraph 8, he says, even if Wood was contrary to earlier authority, this court would be required to prefer the later decision. It follows that none of the exceptions to Young apply. That's not right. Young doesn't say that. Young says that where there are conflicting Court of Appeal decisions, this court has to make a choice between them. I can show you that. That's at Additional Authorities, Bundle 1, tab 12. Page 193. And at page 200, it's the last substantive paragraph. In considering question whether or not this court is bound by its previous decisions and those of courts of coordinate jurisdiction, it's necessary to distinguish four classes of case. The first is that with which we are now concerned, namely the case where this court finds itself confronted by one or more decisions of its own or a court of coordinate jurisdiction which cover the question before it, and there is no conflicting decision of this court of a coordinate jurisdiction. Second is where there is such a conflicting decision, and in that second class, that's dealt with on page 201, 4 lines down. In the second class, the court is unquestionably entitled to choose between the two conflicting decisions. Now,
And bound to do so, really.
and bound to do so.
I've always thought entitled was rather an odd word in that
Yes.
sentence.
Yes, I agree. Yes. Well, here's what we consider to be the conflicting decision, whether or not this court agrees. But this is the decision we have most difficulty with. It's the Prince Ease case in Core Authorities bundle, tab 9, page 148. And we can see immediately what this case was actually concerned with if we look at paragraph 1 of Lady Justice Asplin's judgment, where she says, this appeal is concerned with whether the law, she's talking about the law generally, in relation to bribes and secret commissions, is engaged in the circumstance of this case and the nature of the relationship which must exist between the proposed recipient of a secret payment and a contracting party before the effect of the promise to make the payment renders the contract between the contracting party and the promise of a relation to secret payment void or unenforceable. And then I'd like to start in terms of the analysis with the judgment of Lord Justice Longmore, which is at page 169. And at paragraph 61, he says the present case has an initial similarity to Grant and Gold exploration, but the difference, as he comes on to explain, is that in that case there was a fiduciary, but Prince Ease was not in a fiduciary position. We then pick it up at paragraph 62. He says, 3 lines down, in the Grant case, this court held that the law about secret commissions was engaged because, although the agreement with Mr. Govan was initially made without a corrupt intent, it was in fact made with a director of the syndicate who owed duties of loyalty and was in a fiduciary relationship with the syndicate. And then he quotes Lord Justice Collins. From the beginning, Mr. Grant dealt with someone whom he knew was to stand in a fiduciary relation to the purchaser and who, as such, was debarred from receiving a commission from the vendor without disclosing that fact to the purchaser. And then at paragraph 63, this is really the key point. What emerges from this decision is that for the law about secret commissions to be engaged, the status of the alleged agent has to be a fiduciary one in relation to his principal. And then he says that's clearest from the judgment of Lord Justice Collins. And he said that in 64, the judge below, which was Honour Judge Kaiser, was entirely correct to focus on that question. He considered it a great deal, took account of all the relevant indications, careful evaluation. He concluded that the intermediary in that case, Mr. Oberhor's authority was ministerial, and he said he couldn't interfere with that conclusion. But it's really paragraph 63 which says in terms something rather different to what Lord Justice David Richards says in Wood about there not needing to be a fiduciary relationship. And this is not the minority judgment. It's reflected also by the judgment given the main judgment, which is that of Lady Justice Asplin. And if we go back to that, at page 159, we see that issue 1 on that page is the law of bribery and secret commissions engaged? And what's being submitted by counsel at paragraph 30 is that in order to engage the law of bribery and secret commissions, Prince Ease must show that there was a fiduciary relationship between him and Mr. Oberhor, the promise related to that fiduciary relationship, and there was a realistic prospect of that being impugned by the promise. Then Lady Justice Asplin deals with the point at page 163, and at paragraph 38, he says, in order to engage these principles, is it enough that the recipient of the payment or promise is an agent of the contracting party of whatever kind, or is the requirement more subtle? Mr. King says that the principals are engaged where the recipient is someone who has a role in the transaction. Now that's important because that's the same language that we see at points of time in the Wood judgment. And halfway down this paragraph, the court says, it seems to me that it is possible, but that does not progress matters very far. Whether the law of bribery is engaged is dependent upon the nature and extent of the fiduciary duties owed by the recipient of the benefit of the promise. Of the benefit or a promise of the benefit, if any, the nature of the transaction in question and the relevant circumstances. The inquiry is inevitably extremely fact-sensitive. And then quotes from Bousted, the facts and circumstances must be carefully examined to see whether, in fact, a purported agent and even a confidential agent is in a fiduciary relationship to its principal. It does not necessarily follow that he is in such a position. And equally, paragraph 39 is worth reading. It's clear from the authorities that in order for the law of bribery and secret commissions to be engaged, there must be a relationship of trust and confidence between the recipient and the benefit of the promise, or the promise of a benefit and his principal. That's the language of fiduciaries, which puts the recipient over the page in a real position of conflict between his interest and duty. Not all agents will be in such a position. The relationship may arise where there is no agency at all. It all depends on the nature of the individual's duties and on which those duties is engaged in the precise circumstances under consideration. Although the relationship of principal and agent is a fiduciary one, not every person described as an agent is the subject of fiduciary duties. And one person described as an agent may owe fiduciary duties in respect of some of his activities and not others. And then she goes on in paragraph 41 to give the classic description of a fiduciary as per Bristol and West. And then in 43, the requirement, halfway down 43, the requirement that the recipient of the payment or the promise must be someone with a role in the decision-making process, and she's referring to what I might call the novership test there, per Mr. Justice Christopher Clark. She's very clear that that's not the litmus test in all cases. What she says is that requirement of somebody who with a role in the decision-making process, or someone who is in a position to influence or affect the decision-taking principle, seems to me to be no more than a means of satisfying the central criterion, I emphasise those words, the central criterion that the recipient owes fiduciary duties to the principal in relation to the transaction in question, and a means of determining the extent of his obligations and fiduciary duties. To make sure I've covered what I want to say here. Yes, if we go over then to end of paragraph 44 at page 166, talking about the facts of this case. In those circumstances, the judge decided that the requisite fiduciary duties were not owed by Mr. Opar to the Prince, and accordingly, the law of bribes and secret commissions was not engaged. In 48, I see no error in the way that the judge carried out his analysis. And then on page 169, at paragraph 59, she found that it was not necessary to consider the other issues in the case, having upheld the judge's decision that there was no fiduciary duty. Therefore, the law of bribery had not been engaged. Now, if we just left that there and pre the decision in Wood, one would think that that had settled the issue.
Well, the issue wasn't even in play. That's the problem. The issue in Eze was whether or not the court could interfere with a fact-finding by the judge made at first instance that the so-called agent wasn't an agent but was acting in, or was an agent in the loosest sense, but was acting in a purely ministerial capacity, i.e. a purely administrative capacity. And on any view, an agent who's acting in a purely administrative capacity can't be said to owe either of the duties. I think that seems to be clear across the board.
Yes.
So what you've got is an entirely orthodox application of Mothew and all that line of authority saying Prince Eze wasn't one of those types of people. But it wasn't necessary for the Court of Appeal in that case to start going into what in fact is meant by a fiduciary relationship, which is what Lord Justice Richards does in Wood.
Well, if all Lord Justice David Richards is doing in Wood, and I'm going to come on to this point, is explaining what is needed in these sorts of cases to establish a fiduciary relationship, I have no problem with that. What I have a problem with is the idea that
he's created an extended category or a different category.
And it leaves this really odd situation where you might be able to say, well, you're not a fiduciary, you're not under your duty of loyalty, but yet you are under a disinterested duty. That's the conceptual difference.
Yes, I understand that.
That's the first difficulty. And the other difficulty is how that ties in. And I entirely appreciate this depends on how one interprets Wood. And that's what hopefully this case is going to be about and might provide some guidance on. In terms of the difficulties then with Mothew, which we saw referred to there, can we just look at Mothew itself? That's core tab 3. Page 20. The relevant page is page 35. And it's just this, below letter C. The expression fiduciary duty is properly confined to those duties which are peculiar to fiduciaries, and the breach of which attracts legal consequences differing from the consequences upon breach of other duties. And when we say the duties, that obviously leads into what might think of the consequences of those duties or aspects of those duties, which is, of course, the no profit rule, the no conflict rule, and so on. And over the page, at page 36, he says between F and G, what he's talking about here is not just a question of semantics. It goes to the very heart of the concept of breach of fiduciary duty and the availability of equitable remedies. And then that links into the top of 37. This leaves those duties which are special to fiduciaries and which attract those remedies which are peculiar to the equitable jurisdiction and are primarily restitutionary and restorative rather than compensatory. And then we get I'm not going to read the well-known passage where he identifies the distinguishing obligation as being single-minded loyalty. And it's from that the no conflict, and this is the point, it's from that the no conflict and no profit rules arise. And at the end of that paragraph, he says, these are the defining characteristics of the fiduciary. As Dr. Finn pointed out, he is not subject to fiduciary obligations because he is a fiduciary. It's because he is subject to them that he is a fiduciary. In other words, if someone is subject to the no conflict, no profit rules, they are a fiduciary. That is really drawn from Dr. Finn's seminal 1977 work, and in a sense what this decision was doing, in obviously later decisions, was bringing that academic analysis into English law. And it's just to emphasise this, I just want to turn just to short aspects of Dr. Finn's work, which are in the additional authorities bundle at tab 65. It might be in your bundle 4, it's in my bundle 3. Tab 65 for the additional authorities. At page 1717. At just at the top of that page, In the writer's opinion, it should be recognised today that equity has established and formalised a new and coherent head of law. As will be seen, it has evolved a series of self-contained obligations, which are themselves certain and distinct, and which individually define their own fiduciary for their own respective purposes. These obligations attribute no large significance to the term used to describe the persons to whom each individually applies. In some instances, he is referred to as a fiduciary, in others as a confidant, and we see that in some of the older cases. The term used is unimportant. It's not because a person is a fiduciary or confidant that the rule applies to him, it's because a particular rule applies to him that he is a fiduciary or confidant for its purposes. In this, equity has developed in some way similar to the law of torts. The particular obligations will be imposed upon particular persons because these persons are carrying out particular activities which require the law's regulation. And obviously this decision, I should say, there's another, I won't go to it, there's a similar sentiment expressed in Matthew Conlon's work on fiduciary loyalty. I'm just going to look at that and see if that's worth actually taking time over. I think it is actually. If we just have page 1697. So this is tab 62 of the additional authorities bundle. It's headed the conflict and profit principles. And he's contrasting these with other duties that are not peculiar to fiduciaries. It says two further equitable principles clearly are peculiar to fiduciaries. The no conflict principle, and the principle that prohibits a fiduciary from receiving any unauthorised profit as a result of his fiduciary position. And then under the quotation, these two principles are widely recognised as being of universal application to fiduciaries. They are peculiar to fiduciaries in the sense that neither they nor functionally equivalent alternative doctrines are applied to actors who are not considered to occupy a fiduciary position. In other words, it is these duties that are particularly associated with the fiduciary concept. There are a number of authorities, I'm just going to give you references to cut down the time, where that's been cited with approval, that concept. These are specifically fiduciary principles. The first is, I'm going to list three: Children's Investment Fund of the Attorney General, as a Supreme Court decision, Core Authorities Bundle, tab 10, page 193. Second is Arklow Investments and McLean Privy Council decision, Additional Authorities, tab 21, page 420. And FHR European and Mancarius Additional Authorities, tab 30, page 946. As I say, from there, if I had a full amount of time, I would go through the various stages that are considered in Lord Justice David Richards' own analysis. But as I say, I'm going to focus orally just on one of those, but just explain the others. The first is that the authorities on which the Wood decision is built have been dealt with in our skeleton argument.
Yeah.
This is tab 3 of the core bundle. At page 103, paragraph 35, and what we've tried to do there is sort those cases into 5 fact categories. But the short point, and I think I really don't need to go through these because I think my learned friend has accepted, certainly for the purpose of this appeal, that those could equally be seen as all situations of ad hoc fiduciary. So I'm just going to take the skeleton on that and skip right over to the next stage of the analysis, which is really this central question of what it means to have a duty to be disinterested and be impartial. Without going through them, none of the authorities that we've just summarised there identify that to be the litmus test. And as I said earlier, one of the problems with just stating that to be, as it were, the touchstone of whether these duties arise or not, is you have a potential problem of circularity unless you start, and to be fair, all the parties in this room have done it this way. If you start by asking what role and function the intermediary is actually performing or undertaking to perform, then you can go on to decide whether that function gives rise to duties that go beyond common law duties, that are fiduciary type duties. Now, we've all done that, but I'm not sure that everybody's been doing that at the county court level. And I'm not sure that the Ombudsman does that, for example, in their consideration of cases that come before the Ombudsman. But if we can accept that that is the right, as it were, decision-making process, then as good a litmus test as any, and I don't think this is controversial between us, is to ask whether the factual circumstances are such that the person or the people involved in the transaction would have a reasonable or legitimate expectation that the intermediary will act with loyalty. And that brings me to the question then, and this is the key question, what's the difference between that, which is at the heart of everybody's understanding of what it means to be a fiduciary, as we've just seen. The obligation of loyalty is the defining obligation that makes somebody a fiduciary. What is the difference between that and a duty of impartiality? And my answer is that this duty to be disinterested is really a description of an aspect of what it means to be in a fiduciary position. In other words, once you've asked the question of what obligations arise, what kind of position that person is in, you are, in all circumstances, really asking the same question. Are the circumstances such as to give rise to a reasonable expectation that the intermediary will act in the principal's interest to the exclusion of his own interest?
Well, won't be selfish.
Or won't be selfish. I mean, but that is
As I read paragraph 102, that's precisely what Lord Justice Richards is saying.
I know. But the trouble, I agree with that. And if that were the way he'd phrased it, I think we wouldn't be having this argument at all. But we have greater difficulty with the idea that, and I'm not going to go through wood, but we also have paragraphs 48, 49 and 50, which don't link the duty to be impartial or disinterested to that concept of loyalty in the same way that 102 does. I totally accept that does. And then it goes on to say, well, you don't need, in effect, a fiduciary duty because you've got the common law. So we could be talking about something else. But if we all agree that we're being driven back to orthodox fiduciary concepts, in other words, we're asking the question whether there is a legitimate expectation of self-interest, of excluding self-interest, then it doesn't matter. And I equally accept, I don't mind whether we use the term fiduciary or not. Dr. Finn didn't mind whether the term fiduciary or not. We have to be clear as to what the underlying analysis here gives rise to it. And what I found, certainly we on our side have found helpful, is to see that this idea of a disinterested duty flows from and is really an aspect of loyalty. And we see that in Dr. Finn's own writing, in his capacity as a Justice of the Federal Court of Australia, in the Grimaldi case, which Mr. Hardwick took you to on a different point. And I think we saw it cited by the Supreme Court in Mr. Weir's submissions. And that is in the Children's Investment Fund case. But can we just briefly look at Grimaldi itself, which is at the additional authorities bundle in my second file, but it's tab 27. looking for page 610. Paragraph, first of all, 174, talking about the fiduciary idea, setting standards of conduct and ensuring proper fiduciary decision-making. There are two discrete parts to Australian fiduciary law. The better known and understood part is concerned with the setting of standards, this is what we're interested in, of conduct for persons in fiduciary positions. Its burden, put shortly, is with exacting disinterested and undivided loyalty from a fiduciary. Hence, for example, its focus on conflicts between duty and undisclosed personal interest, conflicts between duty and duty, i.e. owed to more than one party, and misuse of fiduciary position for personal gain or benefit. In other words, being disinterested is part of being loyal. And then 177, as to who is a fiduciary, whilst there is no generally agreed and unexceptionable definition, the following description suffices for present purposes. A person will be in a fiduciary relationship with another when and insofar as that person has undertaken to perform such a function for or has assumed such responsibility to another as would thereby reasonably entitle that other to expect that he or she will act in the other's interest to the exclusion of his or her own or a third party's interests. That is a proper and widely accepted definition of somebody who is a fiduciary, but that must equally be the definition of somebody who is under a duty to be disinterested. And so, in some ways, it's with respect, it's unhelpful to describe the underlying test as whether a disinterested duty is owed, simply and leaving it there. The test must be whether the intermediary has taken on a role and functions on behalf of another that engender a reasonable or legitimate expectation of loyalty to the principal's interest. And if so, the duty to act in a disinterested manner arises. But equally, this is a classic test for this is a classic fiduciary test. There's a similar sentiment in also in this bundle. Tab 32, we have the UBS and KWM case. I just want to look at paragraph 112. This is on page 1010. The mischief which the principal is aimed at preventing is the secret deprivation of the principal of the disinterested advice which he is entitled to expect from his fiduciary. The principal thinks he is getting the loyal and disinterested advice of his fiduciary when in truth he is not. This abuse may be achieved by a secret payment to the fiduciary by the other party to the contemplated transaction, but it's not the only way in which it can be achieved. The fiduciary may be disabled from giving disinterested advice by a multitude of surreptitious means. So in other words, this again, it's all in the same sort of language. The requirement to provide disinterested advice is an aspect of, a consequence of him being a fiduciary. And in my submission, to find that there is a disinterested duty outside of the context where a fiduciary of loyalty, a fiduciary duty of loyalty is owed, it is in danger of causing confusion. And if we go back to Mothew itself, apologies for doing it this way, but if we just briefly go back to Mothew itself at Core Authorities, tab 3, at page 40, we see there in the judgment, Lord Justice Millett's reference to Nocton and Lord Ashburton. A solicitor had an undisclosed personal interest in the transaction on which he gave his client advice which was to his own advantage and the disadvantage of his client. And a few lines down, the plaintiff was entitled to receive and thought that he was receiving the disinterested advice of a solicitor with no other interest in the transaction. Now that's just a few pages after Lord Justice Millett had emphasised that these duties or obligations are special or peculiar to fiduciaries, as we've just seen. And I suppose my problem with Wood is that Lord Justice Millett cannot have had in mind some parallel duty, a duty other than a fiduciary duty, which works as a functional equivalent to this duty in equity, but gives rise to the same no profit and no conflict rules, and yet is somehow not a fiduciary duty. And what's going on here is, in my submission, simply describing an entitlement to disinterested advice as being part of what it means to be owed a fiduciary duty.
Which particular passages in Wood
Yeah.
are you taking issue with? If you say that 102, which is the crux of it, can be read in a way which is compatible with all these authorities.
Yes. If we go to Wood at tab 11,
Yeah.
starting, it requires a close reading of paragraph 48 onwards. And as I say, this isn't just, in a sense, I'm trying to argue against myself. I'm not saying this is my reading of it. I'm saying this is the way it's being read. And that's the concern. To ask in cases of this kind whether there is a fiduciary relationship as a precondition for civil liability in respect of bribery and secret commissions is, in my judgment, an unnecessarily elaborate or perhaps inaccurate question. Now, in a way, I have no problem with that, because
That's about labelling.
it's a labelling issue, and as Finn and as Lord Justice Millett say, you don't need a fiduciary relationship as a starting point. The fiduciary relationship is there because you have fiduciary duties. So one could reconcile that. And then if one reads on, so I can't quite remember where I got to now.
You were in paragraph 48.
Thank you very much. Yes. The question, he says, is an altogether simpler one of whether the payee was under a duty to provide information, advice or recommendation on an impartial or disinterested basis. If the payee was such under a duty, the payment of bribe or secret commission exposed the payer to civil remedies. And
No
then
further inquiries to the legal nature of their relationship is required. Isn't what he's saying there? You don't need to show that the relationship falls within one of the recognised categories that gives rise to the label fiduciary, but rather you're concentrating on the nature of the obligations and the duties and the functions. And if they are such as to give rise to a duty to provide everything on a disinterested basis, in other words, that's another way of saying to act loyally, then you're into the realms of fiduciary duty.
well,
I
as I
can
say,
see how it could be misinterpreted,
Yes.
Mr. Wilson.
well,
can see
I
that
don't have any
entirely.
difficulty with your ladyship's interpretation.
But that it seems to me is what he's getting at, because you then have to see how he draws all the ends together in 102,
Yes.
and again at 110, because
Indeed, how it's
110
applied.
particularly, where he says, well, on the fact findings made by the two judges at first instance, on the basis of the terms and conditions and on the basis of the findings of fact, the brokers owed duties which engage the laws applicable.
Yeah.
Because it was under a duty to make a disinterested and to the extent necessary, they were also correct to hold that he could owe a fiduciary
Absolutely.
duty.
But look, if we're going to interpret Wood as being, as it were, the ratio of Wood as being 102,
Yes.
where the duty of loyalty is the same as the duty to be disinterested, I'm going to stop talking, because that we don't have a problem with that. But where it has led to difficulty is really this. If you try and separate out the two, you get into a problem. Either a duty of loyalty is owed or it is not. If it is owed, then the person is entitled to be disloyal, which means he's entitled to have his own interests and pursue those interests. But it would then make sense, having concluded that there's no duty of loyalty, to reimpose it, or as it were, see it through a different light of being disinterested. That's the difficulty. And if a duty to being disinterested is owed, it's impossible to see how it follows that a duty of loyalty wouldn't also be owed. They're just aspects of the same thing. I think we're in agreement with each other, happily. I think there's one other aspect that I do need to just...
Can I just ask you a question, if I may, and forgive my one of those questions which exposes my ignorance. A bribe, is your submission that the tort of bribery is only engaged with fiduciaries?
Yes.
You bribe a fiduciary?
Yes, and that's the...
So to take an example, I was trying to think of one the example I could think of off the top of my head, and apologies for that, is if one was at a sport football match, let's say, and bribed the referee. The referee's not a fiduciary. Is that not bribery?
I'd have to think about that.
Okay, but your submission is anyway is that bribery.
My submission is that if you trace through this, I haven't got time to do it, but if you trace through this, until Wood, there wasn't really a distinction between those categories which would be regarded as they would be regarded as ad hoc fiduciary situations anyway.
Okay, that's fine. No, that's fine. I just wanted to make sure that was.
Yeah, that is my submission.
Because that was obviously what was exercising, not the football.
Yes, it was. It was. But then when you go through the actual examples he's given, you can actually describe each of those fiduciary relations. I haven't got time to go through them.
No, that's all right.
Some of the academic articles I've put in do exactly that exercise.
Okay, thank you.
Sorry, there was one other aspect of Wood that I do need to address, which is going back to that novership test, the question of role in the transaction, whether that's what that means. We see, just because we're in Wood now, we just see that for reference in paragraph 51, I think it is. Yes. So if we just reread 50 and 51, he's saying, and this is part of the slightly problematic part, where there is a fiduciary relationship, that's not the essential precondition. Much simpler question. Well, it sometimes may be appropriate to describe the duty as fiduciary. It's not necessary to do so. It's the content of the duty, not the label attached to it, that matters. And I should add that in most of the cases on bribery, the secret commissions is referred to as applying to agents, whether or not they owe fiduciary duties. As will appear, I doubt whether the law on bribery is restricted to an agent properly so called. I mean, I would entirely agree with that, because there are all sorts of agents who don't give rise to fiduciary duties, and there's all sorts of fiduciaries who aren't properly called agents. But anyway, he goes on to say, it's enough, in my view, that the person who is offered or paid a secret commission is, as Justice Christopher Clark puts it in Novership, someone with a role in the decision-making process in relation to the transaction in question, e.g. agent, or otherwise someone who is in a position to influence or affect the decision taken by the principal. Now that's the other aspect that's been taken of this as ratio. That's in fact been taken as step one in the analysis. Does the person have a role? Answer, yes, okay. Is he under the disinterested duty? Answer, the law of commissions is engaged. Now, obviously, much depends on what it means to have a role. And I think my learned friend, when he made submissions, made fairly narrow submissions about, well, they took a rather narrow view of what that might mean. But it could, as we say in our skeleton argument, the problem is it potentially captures a number of situations which ought not to engage the law in this area. And a classic example would be a wholesaler which receives a commission on sales paid by the manufacturer of goods. The wholesaler recommends the goods he is selling and perhaps encourages a retail client. It will have a role in the decision-making process, but that's not enough. That's not enough. And we cite two other examples, which I won't go through in paragraph 53 of our skeleton argument. In effect, it's in danger of capturing ordinary counterparties to transactions. It's in danger of capturing search engines and the like. Now, we saw, and it's probably maybe worth going back to it, that in in the Court of Appeal in Ease, Lady Justice Aspin looked at this very same test and described it as no more than a means of establishing the central criterion of whether the recipient owes a fiduciary duty. That was paragraph 43 of Ease. In terms of what a better way of looking at this would be, we have looked at quite a helpful article of Professor Lionel Smith from 2014, and that's an article which has already been referred to because it was referred to in the Court of Appeal in Alnehan and Kent. Perhaps we just look at that very briefly, and I'm going to be able to give my friend some time shortly. This is Supplemental Authorities Bundle, tab 8. Page 338. And we see it immediately that under orthodox principles, the term role isn't really enough. You have to, as is put here, fiduciary duties typically arise when one person undertakes and is entrusted with authority to manage the property or affairs of another and to make discretionary decisions on behalf of that person. Such duties may also arise where the responsibility undertaken does not directly involve making decisions, but involves the giving of advice in a context, for example, that of solicitor and client, where the advisor has a substantial degree of power over the other party's decision making. And I would respectfully say that that's a more helpful way of thinking of it than simply a role. And that is drawn from this article of Professor Smith, which we'll look at in just a moment. But he goes on to say, the essential idea is that a person in such a position is not permitted to use their position for their own private advantage, but is required to act unselfishly in what they perceive to be the best interest of their principal. This is the core obligation of loyalty, which Lord Justice Middleton Matthew describes as a distinguishing obligation. Loyalty in this context means being guided solely by the interests of the principal and not by any considerations of the fiduciary's own interest. So then the article itself is in the Supplemental Authorities Bundle, tab 15, 17, I'm so sorry, tab 17, page 541. At 541 at the top, the requirement of loyalty. Although they may disagree about many things in relation to fiduciary obligations, courts and commentators agree that the law of fiduciary obligations is about ensuring loyalty. Loyalty means allegiance or dedication. Perhaps as a matter of logic, one could talk about being loyal to oneself, to thine own self be true. But as a matter of usage, that is exactly what loyalty is not. It is defined in opposition to self-interest, which takes us back to a point we were saying earlier about disinterested being synonymous with being loyal. To say that a person has an obligation of loyalty or duty of loyalty would be to say that the person is obliged to act with such an other regarding disposition. Many pronouncements of the court suggest that the obligation of loyalty is the distinctive and defining feature of fiduciary relationships. And it refers to Bristol and Matthew, the distinguishing obligation of a fiduciary is an obligation of loyalty, and to Hilton and Barker, Lord Walker, with whom the other judges agreed that the solicitor's duty of single-minded loyalty to his client's interests is the reason for the rule against conflicts of duty. These dicta suggest that a requirement of loyalty is found in all fiduciary relationships and is essential to their categorization as such. A moment's reflection shows that this must be true. A person who held the powers of a director over a company, but who was free to use those powers in their own interest, would be legally categorised as a director, and would not be legally categorised as a director. The same way as if we think of a person who held legal powers that go with any of the traditional fiduciary categories, a trustee, an agent, a partner, and we imagine that the person was free to use those powers exactly as they wished in their own interests, then it would be impossible to say that they were a fiduciary. that makes me wonder, by the way, whether this is dangerous, whether an answer to the referee point is that the person is not in a position, is not a category of fiduciary. But there could be situations where you would treat it as ad hoc fiduciary, where when he is acting qua referee, he is in fact under an obligation to be loyal in the sense of fulfilling his function as referee and not acting in his own interests in fulfilling that function. But anyway, that's a ill thought out, off the cuff response to that question. But let me carry on with this at 544, where the author introduces the concept of autonomy, which we think is quite helpful. In every fiduciary relationship, the fiduciary acquires control over a part, or in some cases all of another person's autonomy. Autonomy is a person's ability to control what happens in his or her life. Autonomy itself cannot be transferred, but the law does contemplate the transfer of certain levers by which autonomy is realised. And then page 545, at the very bottom, in many of the ad hoc cases, ad hoc fiduciary cases, sometimes even the per se case, which is established categories, the fiduciary does not have what might be called legal or Hofeldian powers over the beneficiary. Many of these relationships are purely advisory. This is true of the case of many solicitor-client relationships, which are per se fiduciary relationships, and also in the case of financial advisory relationships, which may be ad hoc fiduciary relationships. In an advisory relationship, the fiduciary cannot make decisions that directly affect the legal situation of the beneficiary. But here too, one can see the relationship as one in which there has been a partial transfer of autonomy. The reason that the advice is an exercise of judgment aimed at helping the person to make choices. If, therefore, the nature of the relationship is such that the advisor, and again, has effective power over the advisee's decision-making process, there is a partial transfer of autonomy, just as in the case of Hofeldian powers. And I'll just read this last bit, just skipping the next two paragraphs. Deciding whether a relationship is truly advisory obviously requires an examination of the relationship. The court may look for an undertaking to advise solely in the other's interest, or alternatively for a mutual understanding that one of the parties has relinquished its own self-interest and agreed to act solely on behalf of the other party. The court will inquire also whether the advisor has effective power over the advisee's decision-making. Cases suggest that the distinguishing characteristic between advice simpliciter and advice giving rise to a fiduciary duty is the ceding by one party of effective power to the other. It is this mutual conferring and acceptance of power to the knowledge of both parties that creates the special and onerous trust obligation. These issues may also be expressed with the language of undertaking, but in the end the inquiry is the same, whether there's been a partial transfer of autonomy. The argument in this section has been, this is the final paragraph I'm going to read, the argument in this section has been that the requirement of loyalty is present in all fiduciary relationships as a matter of the proper interpretation of the powers held by the fiduciary. These powers may be legal or factual. They can come from any source, whether it's contractual grant or grant of statute or by common law. If the proper interpretation of the power is that the holder can use it the way they wish, they are not fiduciary. If the proper interpretation is that they hold it for and on behalf of another, then they are fiduciary and they're subject to the requirement of loyalty in the exercise of that power. So one can derive from that putting the questions in those ways, in that sort of way, and it doesn't need to be tied to that language, come very close to the way that certainly at this level, at this Court of Appeal, we've been asking questions about what the car dealer's role is and whether they could be seen to owe the relevant duties. So, in other words, one reduces it down to two slightly different questions than have emerged from the Wood decision. The first question is, does the intermediary, the dealer, have effective power over the principal's decision-making process? Not merely a role, but effective power. And that explains why we've been having an argument about the panel of lenders and whether there's a selection process going on, and so forth. So if it's all agreed that a dealer gives that kind of advice, provides a best deal outcome based on a selection which it is making, and it's having that function delegated to it rather than the customer carrying out that function itself, that's the kind of decision-making process we're interested in. It's not particularly helpful to call that a role. It's more helpful to think of whether there's a delegation or power over a decision-making process. That's stage one. Stage two, does the intermediary have such power in circumstances where there has been a mutual expectation, objectively or understanding, that he has relinquished his self-interest? And that's where we get into the whole debate about him being a car dealer and having his inherent interest in the transaction. And personally, I found that a helpful way of separating out the various issues we've been thinking about and seeing how they fit in the analysis. My answer is going to be the same as Mr. Hardwick's answer, is the car dealer in our case did not have effective power over the relevant decision-making process. The decision-making process was that of the customer. There was no selection or anything of that nature. But even if it did, given the dealer's role as seller of the car, cannot be in a position where he has relinquished his self-interest in the transaction. And that, in my submission, almost exactly at 3:30, giving my friend almost exactly 45 minutes, is the answer to this case.
Thank you very much, Mr. Wilson.
I'm extremely grateful to my learned friend for finishing on time and for making no more other than one, I think, criticism of our skeleton, which was entirely unwarranted, and that's the issue I'm going to start with, which is the issue of ratio decidendi. If you go back to our skeleton argument in the supplemental skeleton, at page 448 of the core bundle, we actually set out the exceptions at paragraph 7, which he then took you to in Young, which we'd set out. If you kindly just go back to paras 7 and 8. This is page 448 of the core bundle. We then said CB does not identify any relevant case, because they hadn't at that stage, other than Edis has emerged today as the case, or statutory provision that this court proceeded in ignorance of in Wood. And so we say that you're required, therefore, to follow the later decision. And that, we say, is right in Lord Newburger in a case called Patel against the Secretary of State for Home Department, made this clear. It's paragraph 59. Because Wood considered ease, you are bound to follow Wood. Paragraph 59. I won't take any more time on it. In any event, going to the substance in relation to what does Wood decide, and Wood is binding on this court, that, my respectful submission, there is no doubt. First, the real point that Lord Justice David Richardson, our respectful submission, is endeavouring to make is exactly the point which is exposed by the observation of my Lord Justice Birss in the question asked about the referee. So pre-Wood, if someone characterises the credit broker rather like the referee or the barrister in the case that Lord Justice David Richards refers to, or the Army Sergeant, Attorney General Reading, they may be able to get traction on a submission. That's not a fiduciary. Don't be silly. That's not a fiduciary relationship. You can't impose a fiduciary relationship. That's alien to the world of fiduciary relationships that we understand. And what Lord Justice David Richards was doing was saying, please come away from that label fiduciary just per se, let alone fiduciary established relationships. See those paragraphs 47, etc., in which he's at pains to say, come away from accepted relationships. The value of Wood is even in relation to a specific transaction only, the relevant duty can be owed. And it also provides the complete answer to the complaint that both my learned friends rely so heavily on, that you can't possibly impose a duty on the credit broker who was also the motor dealer? You can. That's exactly what Wood is telling us. It doesn't tell us in relation to the factual context here, but it's saying specifically, look at the transaction. And if in relation to that transaction, and I don't shy from using decision-making process, but my friend says I'm not seeking to use it in some overly broad fashion, but I'm not seeking to have it replaced by the language that an academic has promoted in a 2013 article either. Respectfully to the academic, I'm asking this court to employ the language used by the Court of Appeal. But we understand what's meant by that because I've taken this court through what lies beneath, which is an exercise of judgment or discretion, such that that person is acting on my behalf, involved in my...
And not on his own behalf.
And not on his own behalf, in my decision-making process, such that equity steps in. See the quotes that I've given in the past, including the English case. Now that's Lord Justice David Richards, my words, distilling matters or arrowhead. And that's when actually it does not matter whether this is called ad hoc fiduciary relationship. And I seem to recall an observation from Eleni Leja-Sandris that wasn't necessarily a description that the court favoured. And that's the point. It may be that one court favours a description, ad hoc fiduciary duty, and another one less so, and is uncomfortable with it, or feels that per the judgment in Kent in Mr. Justice Leggett, we've got to look for so-called exceptional circumstances. We don't. And exceptional circumstances was actually special circumstances in the judgment of Lord Justice Mummery in an earlier case. But we don't have to look for something exceptional. We just have to look at the transaction in question, the role performed by the credit broker. And we're not so bold as to say, look, there are actually 4 Court of Appeal cases. Haven't we actually got an established category of relationship now, which we call fiduciary relationship between credit broker and borrower? We don't have to say that. We're content to go on the facts of the case. Absolutely. Absolutely. You look at the facts of the case and in relation to that specific transaction. And that's why, when I think my learned friend Mr. Hardwick said, we're moving on to the second stage, his words, absolutely. First stage was agree a price. At that stage, you are the motor dealer. And there isn't going to be a contract because actually you're not going to buy it with cash. But were you to buy it with cash, the borrower's counterparty would be the seller, the motor dealer, because the motor dealer at that stage owns the vehicle. But that deal does not go through because the borrower, like the vast majority of members of the public in this country, do not purchase their cars because they cannot afford to with cash. They purchase them on finance. And that's why we move to the next stage. And it is a separate stage. That's the point. And there's no sort of difficulty, no logical difficulty, no good sense difficulty, no difficulty at all with then understanding that the motor dealing is acting qua credit broker. And indeed, it's not contested that they're acting qua credit broker. It's just put in issue to, it's muddy the waters in an unfair way, but it's put in issue to confound the court that the person has previously worn a hat called motor dealer. And they had. It doesn't matter. Because now they're not doing that. Now that they want to sell the car, I think my learned friend Mr. Wilson accepts the interests are aligned. So we don't have this so-called conflict that was described as making it impossible to have a fiduciary or disinterested duty at all, certainly recognised by one party. And what we have instead is a function in relation to a specific transaction that does go through. And that function is the function of credit broker. Now, my learned friend Mr. Wilson says, well, he or she or they are introductory agents, as if, I don't know, use of the language introductory agent somehow exculpates them from the relevant equitable duties.
Well, I think what both Mr. Wilson and Mr. Hardwick are saying is that the function that is performed wearing that hat. It is a administrative function of introduction between the person who needs the finance and the person who's willing to provide it, and wearing that hat and doing that is not enough to create whatever label you want to put on it, a duty to act loyally.
Well, lady, yes. But just in relation first, I come to the administrative, because that's substantive. But the introducing agent, can you just kindly go back to the McWilliam case, Core Authorities Bundle, tab 6, page 96. This is where, as part of paragraph 40, but down at the bottom between H and J, Lord Justice Tomlinson says, referencing the Bowsted and Reynolds on agency, under the rubric incomplete agency, internal relationship only, the canvassing or introducing agent, we find the following. And then obviously the whole passage can be read, but if you go over the page, that all rolls down into, right down at the bottom, they also usually act in a capacity which may involve the resolve of trust and confidence, and hence may be subject in some respects to the fiduciary duties of agents towards their principals.
Yeah.
So I'm amused that weight is attached to the description introducing agent. I think that takes him anywhere. The substance is much more interesting. In relation to the substance, and just starting with Hopcraft, which is not the case with the suitability document, it's not the case with Mr. Wrench's evidence, so it's a sort of lowest level of entry. First of all, we have the evidence of Imogen Shaw, and it is strange indeed that we end up in a position where the bank who call a witness who gives evidence are now seeking so overtly to downgrade her evidence. The real position that needs to be adopted has been made clear by the Supreme Court recently in a case called Griffiths and Toohey. And I think Griffiths and Toohey has hopefully also made it to you electronically.
It certainly hasn't made it to me, because I don't have an electronic means in front of me, I'm afraid.
I have a hard copy which has arrived, and I've also got it electronically, which has arrived during the course of this afternoon.
Thank you, Lord. This was in response to submissions which were made
It's quite a well-known
just before lunch. And this
decision.
is a reasonably recent and reasonably well-known decision, and in which Lord Hodge sets out at paragraph 70 at page 1228 the general rule as regards fairness as to what a party and the court should do with evidence given at trial. And so if you see 70.1, the general rule in civil cases as stated in Phipson is that the party is required to challenge by cross-examination the evidence of any witness of the opposing party on a material point which he or she wishes to submit to the court shouldn't be accepted. And it extends to both witnesses as to fact and expert witnesses. Unless the evidence is, and I think the key word was incredible, unless it's incredible evidence that you don't have to cross-examine it, not only does it mean a party is not at liberty then later to make submissions contrary to the evidence which has not been challenged in cross-examination, but the trial judge is also required, unless powerful reasons given to the contrary, to accept it. Of course, learning from Mr. Hardwick has been working extremely hard to undermine evidence which was required to be accepted by the court. So it just doesn't wash. And if we go to the Hopcraft, and I'll start with, that applies across the board, it applies to Hopcraft, it applies to Wrench.
Well, you're in a little bit more difficulty with your own witness in Hopcraft, I think, in the light of what the judge said about her. But
well, my lady, let me start with that then. Let me start with that, if I may. So that's core bundle. That's the judgment, which starts at, it's core bundle tab 36, starts at 398, and what we have is page 403, Para 32 starts, a slightly different position arose from the claimant when challenged, when examined in cross-examination. Para 33, she says that she, open inverted commas, assumed they would get me the best deal. That is evidence she has given in cross-examination. So actually, that's the evidence. And so she suggested if she'd known about the commission, she would have shopped around, but of course she didn't actually do so, etc. It's sotto voce on my right. It's not in inverted commas because it's unbelievable. If a judge wants to consider that evidence to be unbelievable, the judge needs to say so. It's part of the judicial function.
I think the point that's being made is that instead of giving evidence that she was told that she would get the best deal, it's an assumption.
I understand, my lady, and that's why I'm going to this case first, because as I say, it's the lowest entry level.
Yeah.
And to the key evidence of imminent short. But if you're actually just there, can I go back to para 41, please, just before you lose it? Page 405 of the core bundle. I know this passage has been read out to you. At one stage, from Mr. Wilson was saying, well, I don't know, it's very difficult. We really don't know what's happening. We don't even know if multiple offers were made to her. There's so much we don't know. Well, we do know, because we see the judgment at para 41. They gave information, but on the evidence they gave, it is only in relation to the one deal they offered. And then you see, there is no evidence that they gave any advice or recommendations. I suppose one could say on a practical basis, this was the finance deal, take it or leave it. Now that actually captures our point. What is that if it is not entrusting the broker to come back with a deal for you, which implicitly, exactly as per the evidence of the claimant in that case, you'd expect to be a competitive or the best deal. That's an exercise in good sense to understand. That's obviously the position. Here's my deal, take it or leave it. It's not, here is a shocker of a deal, take it or leave it. If we go back to Imogen Short, paragraphs 9 to 10, this is Hopcraft Bundle, tab 2, page 19. Now this...
Sorry, forgive me. My brain has only just caught up, because I've now deciphered my note. In para 33, there's bidding quotes. You told us it was in the cross-examination. Mr. Wilson told us it was a quote from the witness statement. It doesn't matter, given the point that's being made.
No, you won't find the words, assume they would get me the best deal, in the witness statement.
Okay. Just want to make sure we're clear.
Absolutely. It's from cross-examination.
I've now managed to forget what page you were taking us
Yes,
to.
my lady. I'm in the Hopcraft supplementary bundle.
Yes.
I'm in tab 2, on page 19,
Yes.
paragraphs 9 and 10.
Yes, thank you.
Now these submissions are recorded. I'm not saying the court has got so much time on its hands that it wants to enjoy re-watching submissions which were made, but I say with confidence, and then a friend, Mr. Wilson, said, what would need to have happened, this is my words to the effect of, what would need to have happened for there to be a relevant duty is you would need the broker to say, well, what do you actually want? How long do you need to pay it for? And how long do you want to pay it for? And then if you go to paragraph 9, prior to entering into finance agreement, a customer will select a vehicle, either online or in a dealership. Next sentence, if the customer requires finance, it's at this point the credit brokering journey begins, so that complete change of hat, very clear. To begin with, a representative from the dealer will go through an information gathering process with the customer. This will include discussions regarding what deposit the customer wants to put down on the vehicle, what amount the customer can pay each month, and how long the customer wants to finance the vehicle for. The very things that were said, these were needed, are the very things that go through in order here. Hence the seeking to downgrade the quality of this evidence, which was given orally, wasn't challenged on cross-examination, and it should be deemed to be accepted following Griffiths and Toohey. So what you have is, as the submission I've made before, it's very real. You have a person, a customer, when they go to a forecourt of a car, they are exercising their judgment and discretion over the price, because of course you can look online, you can get, people chat about the cost of an Audi TT 2006 model, etc., etc. People are able to exercise their own judgment and discretion.
And at that stage, you accept that the person who's trying to sell it to you is going to try and sell it at the highest price you can get away with, and you're going to try and get it at the lowest price.
Yes, my lady, and actually there's a market force in place because there's such a big market in cars. They can't jack the price up because most things are attached to Glass's guide. You go onto the AA, instantly get told that the right price is £6,400 or thereabouts, but this one's closer to home and it's £6,800. But actually you can't flog it at 10 grand. That's that part. You agree a price. When you then move to the world of you need some finance, then I'm sure not this court, but certainly me, your eyes glaze over. You become deeply unsophisticated in this context. You are reliant. When would a submission recognised? When have I heard a submission from either of my learned friends recognising the vulnerability of these customers? They want to bury that. So although my learned friend Mr. Hardwick says, I completely accept your analysis of the law, which includes the absolute critical importance attached by Lord Justice Tomlinson and McWilliam to the financial unsophistication of the borrowers, you never hear that mentioned because it is so unhelpful to them and so important in this case. And it is exactly at that point that the dealer says, I'll sort it. You give me your financial details and I will get you a product. What is that? Even if you want to use the language of the power language, which we just heard from, so I don't mind particularly, that is entrusting a part of what would otherwise be your judgment and discretion, which you don't really have because you don't know what the APR this and the APR that is in these intensely detailed terms and condition documents. And you are absolutely objectively reliant upon the credit broker in those circumstances.
Well, you'll be looking at the bottom line of what the deal means in terms of how much you've got to pay per month, over what period.
You're looking for
deposit is.
You're looking for help, my lady. You're looking for help. You're absolutely exposed, or using the description of Mr. Justice Mason, High Court of Australia, at the mercy of person who's got your financial details and can set the price that they know you can afford, regardless of its value to you. And it's precisely because they can go to a loan shark that equity intervenes. That's the point. It's no good praying that in aid. It's an extraordinary submission from Leonard from Mr. Hardwick to say, well, actually, there's a deal that's gone on between the dealer and the lender saying, come to us first. And how misleading is that when we go to Johnson and look at the suitability document? That's another breach of duty.
The thought crossed my mind, Mr. Weir, at the time, but I didn't say anything to Mr. Hardwick about it. But it seems to me that document rather shoots him in the foot.
It's just extraordinary. It just exposes what goes on. It's the reality check that we invite this court to engage in, because
There's
this
no
is
question
real.
of selecting anybody. It's always going to be the tie.
We will present a list of 22 panel members.
Which one is our?
But actually, guess what? We've got our own. And that happens to be the biggest commission's case. We don't know if it's the biggest commission. We don't know.
Mr. Weir, can I? Again, I'm sorry. This isn't a referee. This is another half-thought example. You go into a garage to buy a new car, second-hand car, new to you, and there's a discussion about price, and the conversation turns to extras. And you're offered a different paint job. Maybe the garage might say, well, we could paint it purple if you like, or, we see you coming, Lord Justice Birss, you look like a chap that needs a purple car.
If you say so, I hadn't known that until now.
But something like that. So I'm not talking about credit. I'm talking about options.
Yes, ma'am.
And you're completely at the mercy of the car dealer in that circumstance. And the dealer can offer you different options and say, well, you can have this, you can have this paint job for this much, or that paint job for that much. doesn't feel like the same circumstance as the one you're talking about. But the logic of your argument, let's assume those were going to be subcontractors producing it, is that would also be subject to the same issues. And the fiduciary, the payment of a commission, let's say there was a commission payment going from the painter who resprayed the cars to the garage, that would all be part of that would all.
I'm trying to think about it because actually it's about the exercise of judgment and discretion, which would otherwise have been mine, but isn't mine, and you've stepped into my arena and you're making decisions or engaged. That's the language that Lord Justice Richards quite rightly uses about being engaged and influencing my decision-making process.
Why is it different though? Because I mean, it feels to me like you would say that is a different situation, but it's not clear to me what the relevant difference is. Why is it a different decision? I mean, if I'm choosing which paint job.
Well, if that was, for instance, all part of the finance, if that was all being put onto another loan,
nothing to do with credit.
But if it's just cash,
well, just to be clear, Mr. Beard, the point of my question is I'm trying to get the credit bit out of the equation, because I can quite see why, in the context of credit, all sorts of other different things happen. But you've got a Consumer Credit Act that overlays, that is present and deals with all these problems. But the point of your case at the moment is that this has nothing to do with the Consumer Credit Act. This is I'm going to say the common law. I don't mean common law against equity.
Understandable.
I mean the common law is applying here. And why wouldn't it apply if it was the same sort of circumstances that we're talking about, but not a credit situation? And I have a feeling that your case is that it wouldn't apply. And I'm trying to understand why that's different.
It may not. I mean, being bounced into testing. No, I understand. Part of the job, but I'm just saying that. But it means that I want to be very careful before giving an answer, because I don't actually want to just give an answer and say, "Well, you said that," because that's the whole point. Is it's so fact sensitive. Immediately, I'm thinking when it's a paint job, it's like £600. So we've got the quantum of the amount involved. If you're saying it was a £12,000 paint job, I don't know. We might be looking at something that's different. If it's, but we've got aspects in which you are simply assumed by the law to be able to exercise your own judgment and discretion, and we've got aspects in which that has been subsumed, if you like, or overtaken by the agent or credit broker. And it's certainly overt, and we would respectfully submit obvious in these cases, exactly as it was to the Court of Appeals below, and it may feel somewhat less obvious in a different factual scenario that you're promoting. Lord, I'm sorry not to give more of a complete answer than that. But certainly when we look at our scenario and go back, just 2 paragraphs in Wood, if you can kindly go back to Wood tab 11. First of all, I'll give you the page number in a second I find it, but paragraph 113, which is page 273. This is the distillation of relevant facts by Lord Justice Richards, when he says it's the broker, not the client, that had access to a panel of lenders. Now, just staying with the Hopcraft case, that's unarguable in Hopcraft. We see it from Image and Shaw. And then he says, and the broker undertook to work from that panel to provide the appropriate product to meet the client's individual circumstances and needs. And that is inherent, absolutely inherent in you giving them your financial information so that you can have finance, them saying, I'll sort it. Exactly as the learned Deputy District Judge ends up saying, here's the deal, take it or leave it. This is the one deal we're going to give you. And as the Court of Appeal says, this necessarily involved judgment and choice on the part of the broker. And so undoubtedly you've got this critical judgment and choice. That's what I would attach to. That's part of the Court of Appeal judgment rather than other language. And then I would just go back to page 275, para 125, and the pickup case. The judge had said, this is between F and G. At para 40, the judge had said that the broker in that case was not a whole-of-market broker, but had a restricted panel of lenders to whom they would refer customers based on what they considered best fitted their stated requirements. Now that language is almost verbatim the same as the suitability document in Johnson. It's absolutely of a piece with Mr. Wrench's evidence, and of course it fits exactly with Miss Herstanger's evidence as quoted by the learned Deputy District Judge, and it accords with the only rational way of understanding the role in real terms that is being performed by the credit broker in all these cases.
Well, I'm not sure that's entirely right, is it? If they have a basically exclusive tie to one of their 18 lenders, and they give them first refusal in all cases, not exercising much judgment, but it's hard to see how that could improve their position.
My lord, yes, that for me is part of it's probably a separate breach,
Yeah.
because that is in the Johnson case, in which the suitability document is completely at odds with that, and so that's how that has to be construed.
Can I just explore that a little bit more? Because I mean, I'm not talking about the facts of Johnson at all, just to be clear. But you could have a panel, you could truly have a panel where your approach will be that you will approach each member of the panel in order, and the first one will, if they offer you a deal, you'll take it, and then the second one, and then the third one. But and that's how you work through a panel. That's a perfectly rational way of having a panel, which doesn't involve asking more than one panel person for deals that you can compare.
There's a sort of information superhighway in all of this. If you're going to tell the client, all I'm going to do is go to the first person who ticks the box, regardless of price, so be it.
No, what I'm going to do is I'm going to work. I mean, I appreciate that this isn't explicitly stated. Don't worry, I do understand that, Mr. Weir. But you can work through a panel where you say, I'm going to go through the panel in order and give you the first one sequentially, which offers you what you're asking for.
Absolutely. You can also have, and it was raised in writing but never raised orally. You can have the captive lender. You could be attached to them. You could be BMW who only goes, I don't know, to a given bank, whoever that might be. And if you say, look, I'm just going to go to our bank, who'll just give you one offer. I'm not telling you it's competitive. I'm just telling you that's the one that they do. Then I've got the judgment and discretion because you've informed me about all of this.
My point, I think, what I'm trying to make is saying you have a panel isn't the same thing as saying that you are offering the best deal from a selection of the panel. They're not the same thing. That's the point I think that's put against you, and the point that's put against you is you're assuming from the word panel and then reading it out of wood in a particular factual circumstance where it was clear that that was what the panel was for, to assume that any panel is always to be understood that way. And I'd be interested to know what your position is on that.
My lord, yes. I mean, if we start with the Johnson case and look at the Johnson suitability document, it is completely alien to that document so to interpret the provision of a panel. Because actually what you've got, if you go to page 38, so tab 1138 of the Johnson file, there is a word that I didn't actually highlight before at the top as well. It says the Trade Centre Wales is authorised and regulated by the FCA and is permitted to advise on, which I didn't actually emphasise before.
I wondered when you were going to.
Thank you, my lady. Well, better late than never. But anyway, you clocked it before, my lady, so it mattered not. But to advise on and arrange consumer credit contracts, we've then got the best meet your individual requirements, and then we say we don't offer a whole of market, but we offer products from a select panel of lenders, details of which can be set below, and then we say over the page, suitability, and which finance has been selected to provide funds. I mean, Lady Legislator's made the point, if you want to sit over dinner with a group of lawyers for your sins, then you can make this, you can drop it down in value until it's almost nugatory, because that's the role we perform for our day job. But it's not the right way to look at a document that is sent to a customer who starts off as financially, that you have to understand at all stages, is financially unsophisticated.
It's rather like Mr. Hardwick's very clever point about we're looking to find out what's suitable for you. Oh, it's hire purchase only.
It's fun. I enjoy it to listen to, but it's not real. If I can put it that way, my lady. The same applies for Mr. Wrench, because Mr. Wrench said, and I'm going to get the quote wrong, but he said, I think, find me the best rate, that the broker would find me the best rate from their panel of lenders. and that was not undermined in cross-examination, and that is deemed to be accepted evidence. Griffiths and Toohey. And then we've got Miss Hopcraft and what she assumed. So actually, my lord, once there's a panel, and no one answered our point about they must have had authority to go to a panel. No one answered our point and challenged that and said we're wrong about that, which is equivalent to knowledge, we say. If they go to a panel, they must have done so with our authority. Had no submission in writing orally against them. Very briefly, the pleading point in Wrench is a really unfair one. Not only did we plead the necessary elements of a breach of fiduciary duty, albeit not using those words, powers 12 to 13, which are core bundle, tab 28, page 342. But when you go to the defence in two places, 8.10 and paragraph 17, and here you can just, if you just go to tab 29 of the core bundle, one of those references will do 365.
Tab 29.
My lady, yes, at page 365, 8.10. This is the defence. If the facts of the claimant's relationship with the first dealer and or the second dealer meant it was acting as the claimant's fiduciary, which is denied, the defendant or AF didn't know that the first dealer and or second dealer had departed from the universal practice by acting as fiduciary, etc. It was absolutely out there in the pleadings. And no point has been taken, save by way of skeleton argument on a second appeal. The acceptance of the fiduciary duty test, perhaps I've made a submission already, necessarily involves therefore acceptance of the importance of understanding that when a borrower is financially unsophisticated, it can be expected. These were my submissions. He said he didn't challenge them at all. It can be expected that the borrower will not be exercising his own judgment, and the broker's exercise of judgment will be capable of affecting the borrower's affairs. I added that the lack of financial sophistication put the borrower at the mercy of the broker, and, quoting from McWilliam, meant that he's vulnerable to any disloyalty by the fiduciary and so reliant on his good faith. In relation to accessory liability, my lady, one point which I wish to make, because I'm not sure if this has necessarily been clocked. At this stage, we're dealing with a half-secret case, and the dishonesty which equates for these purposes to knowledge does not attach to knowing that there may be a commission, because we're in a half-secret case already. The dishonesty or lack of knowledge, or knowledge rather, relates to knowing that the borrower was not fully informed. In other words, that the borrower was not told that a commission was going to be taken and the amount of the commission. So it doesn't help Firstrand to say, well, we had a contract with the dealer in which we said, please make sure you say that a commission may be taken. Doesn't help them at all. And Trafalgar, the judgment of Lord Justice Stuart Smith I went to before, at paragraph 43, makes really clear what needs to be set out. I'll just give it a reference. It's Additional Authorities, Bundle 3, tab 42, page 1349. Nor does Conk help them, because Conk only says at that point, that's the 4.5.4, that you need to disclose the amount of the commission at the request of the customer. That's Additional Authorities, Bundle 4, tab 56, page 1578. In relation to whether Wrench was a fully secret or a half-secret case, there was a long preamble from learned friend Mr. Hardwick in relation to the difficulties that lenders experience. Well, the arrangement and contractual terms between the lender and the broker are irrelevant to this issue. What matters is, an issue of fact, what was Mr. Wrench told? And the appeal has proceeded throughout on the basis that the only route for Firstrand to suggest that Mr. Wrench was informed there may be a commission was via the terms and conditions that you find in the Wrench bundle at page 44. So instinct relied upon by Mr. Hardwick does not come into it. If the bank's paid a commission and the customer didn't know about it, this does engage the law of bribery and secret commissions. And Close Brothers, for instance, are an example of a bank having to accept that. So we don't get anywhere with instinct either. It's not entirely clear whether it was accepted that the burden of proof rests with the defendant in relation to this issue. Certainly I did not hear any substantive answer to the way in which we put the case, which is on the basis that you start with the duty, the breach is by payment of a commission, and then the whole issue of knowledge and consent is part of the defence. And there's a staged process where you can get to the halfway house. It couldn't be clearer when you go back to the judgment of Mr. Justice Briggs in Ross River, hours 203 to 204, Additional Authority Bundle 1, tab 25, page 547. As to the test to be applied, common ground it's an issue of fact, or we would readily accept the observation of my Lady Justice Andrews' fact and degree. We would also respectfully adopt the description of my lady that it must turn on whether it is sufficiently apparent on the face of the document or not, which seems in our respectful submission to capture that which is required. As to would at paragraph 127, if we can just nip back please to that. So that's Core Authorities Bundle, tab 11, page 276. Starts at 275, but goes into 276. Our first submission is that what is being recorded there are the submissions of the defendant. My Lord, it's para 127. Your Lordship will recall that we rely on para 120, and we've sought to give that its proper context. And then it was put against us, well, additionally, that doesn't sit with para 127 on the issue of half secret. And we say, first of all, this was a classic case where what you get, and this happens quite a lot, is a judge recording someone's case rather than actually providing their own evaluation. Anyway, we say Wood is much more like Herstanger, because the Wood document was a broker document that was given in advance of the borrower signing the loan. You know it was signed because you see that at paragraphs 120, where it's confirmed it's signed, and you can also infer it from the clauses on paragraph 17, page 252, I think it is. It's a 2-page document. It's given in advance, exactly in line with Conk, that it should be given in advance of the loan. It's only 2 pages. The provision in relation to commission is clear and there to be seen, and it's signed. So we don't accept, and we instead submit that it shows the difficulty that learned friend finds himself in when he describes factually there's no distinction between this case and Herstanger. Factually, there are multiple distinctions. Herstanger involved a pre-contractual document. Headed, please read this communication carefully. And then following up with, by signing same where indicated you confirmed you've studied and understood the contents. To be contrasted with this case, where the terms and conditions are a separate unsigned document, where attention is drawn to clause 10, which is actively misleading as regards attention being drawn to anywhere else, including clause 12.3, if you can read it, and where Mr. Wrench A, didn't read the documents, and B, the broker knew this. And you see this in the transcript of the evidence. Wrench, tab 20, pages 93 to 94 and 130 to 131. And our position in relation finally into the disinterested duty, and is it sufficient in halfway house cases and so forth. Your Ladyship already fully understands our position, which is it's not so much whether it's called an ad hoc fiduciary duty or not. It's a distillation and focus so that you are not misled into not inviting equity into the party simply because of your concern that this doesn't feel right as an equity lawyer used to the language of fiduciary duties. That's the substantive content of the judgment in Wood. The logical corollary of that, and here Mr. Wilson and I are actually, as I said in my opening submissions, far closer than might be otherwise understood, is that the same duty must apply in the fully secret and half secret case. See our structure: duty, payment of commission, breach. Now look to knowledge and consent. My lady, that clock is slightly fast, and I think it's now 4:15, and those are our submissions in reply.
Thank you very much indeed. I'll just check and see if there are any questions. No. Well, thank you very much, Mr. Weir. Thank you to everybody, whether they had a speaking role or not. And thank you very much particularly to those sitting behind the barristers. We know that an awful lot of work has gone into the preparation of the bundles, and although we grumble about being deluged with paper, we know that in a case like this it's necessary. So thank you all very much. It will come as no surprise that we will reserve our judgments. We will obviously aim to get them to you as soon as we can. Usual rules will apply. Hand down draft. They will be circulated in strict confidence to those people whose details have been supplied to my clerk. If there's anybody else you want to add to the list, please let her know. And as I don't think I need to remind anybody in this court, we do take the obligation of confidence extremely seriously, and there will be serious repercussions, as per the Attorney General for Wales case, if anybody breaches them. Attendance will not be necessary when the judgment is handed down. It will be done remotely. We do try to ask you, we try to give you plenty of time to try and agree an order, but we know that counsel are always very busy and that sometimes you can't get hold of clients and that you might need a bit more time. I will say this, that it would help us, I think, if you tell us as soon as possible when we intimate we're going to hand down the draft how much time you think you're going to need, because I always think that it's less tidy to hand down more than one order, and in particular if the losing party or parties wanted to take the matter further, they should be thinking about that as soon as possible, because we do not have the power to extend time. That's all I need to say about that, I think, but thank you all very much indeed.
Court rise in favour.